this case is whether Linda have liability or not. First, the law. The relevant case for this situation is Section 11 of Contract Act 1950, where minor can enter into valid contract. Based on this provision, we can understand that in order to make a valid contract, the minor must be in the exceptions. The exceptions are contract for necessaries and insurance contract. The relevant case for the situation is the case of Nash v. Inman. In this case, a minor entered into contract with a tailor to supply clothes including fancy waistcoats. Unfortunately, the minor fails to pay and the tailor wanted to sue the minor. The court held that although the clothes were suitable according to the minor's life, they were not necessary as he already had sufficient clothing.
Based on above law, Jimmy Choo London Collection cannot ask Linda to pay the bill because the shoes is not necessary. Next, Malaysian Insurance, Paradise Village Resort and Celcom Cellular Phones can request RM1600 to Linda for her first annual premium. In conclusion, Jimmy Choo London Collection cannot ask Linda to pay the bill, but Paradise Village Resort and Celcom Cellular Phones can request RM600 to Linda for her first annual premium.
This is the case details for case Freeman v. Kiamisha Chonker. On January 7, 1974, the case of Freeman v. Kiamisha Concord, the Brian M. Freeman plaintiff v. Kiamisha Concord Incorporation defendant. The facts. Plaintiff, a lawyer, has commenced this action against the defendant, the operator of the Concord Hotel Concord, one of the more opulent of the resort hotels in the Catskill Mountain Resort area, to recover the sum of $424. Plaintiff seeks the return of charge for 2 days spent at the hotel and not refunded after he and his wife checked out before the commencement of the 3rd day of a reserved 3-day Memorial Day weekend. Plaintiff asserts that he is entitled to the sum pursuant to the provision of Section 206 General Business of the General Business Law. Testimony adduced at the trial reveals that in early May 1973, after seeing an advertisement in the New York Times indicating that Joel Grey would perform at the Concord during the forthcoming Memorial Day weekend, plaintiff contacted a travel agent and solicited a reservation for his wife and himself at the hotel. In response, he received an offer of a reservation for a 3-night minimum stay, which contained a request for a $20 deposit. He forwarded the money, confirming the reservation which was deposited by the defendant. While driving to the hotel, the plaintiff observed a billboard located about 20 miles from his destination, which indicated that Joel Grey would perform at the Concord only on Sunday of the holiday weekend. The plaintiff was disturbed because he had understood the advertisement to mean that the entertainer would be performing on each day of the weekend. He checked into the hotel notwithstanding this disconcerting information, claiming that he did not wish to turn back and ruin a long-anticipated weekend vacation. The plaintiff later discovered that 2 subsequent New York Times advertisements not seen by him before checking in specified that Grey would perform on the Sunday of that weekend. After staying at the hotel for 2 days, the plaintiff advised the management that he wished to check out because of his dissatisfaction with the entertainment. He claims to have told them that he had made his reservation in reliance upon what he understood to be a representation in the advertisement to the effect that Joel Grey would perform throughout the holiday weekend. The management suggested that since Gray was to perform that evening, he should remain. The plaintiff refused and again asserted his claim that the advertisement constituted a misrepresentation. The defendant insists upon full payment for the entire 3-day guaranteed weekend in accordance with the reservation. Plaintiff then told the defendant's employees that he was an attorney and that they had no right to charge him for the 3rd day of the reserve period if he checked out. He referred them to the text of Section 206 General Business of General Business Law, which he had obviously read in his room where it was posted on the door, along with certain other statutory provisions and the schedule of rates and charge. The plaintiff was finally offered a 1-day credit for a future stay if he made full payment. He refused paid the full payment charge under protest and advised the defendant of his intention to sue them for treble damage. The basic issue is a resort hotel which contracts with a guest for a minimum rate weekend or other fixed minimum period stay in violence of Section 206 General Business of the General Business Law and subject to the liability provided therein if it insists upon full payment from a guest who checks out prior to the expiration of the contract period.
Certainty can be defined as being free from any doubt and confusing. Under Section 30 Contract Act 1950, the terms of contract must be certain, which are clear and complete in order to create a valid contract. If any terms in the agreement are not complete or clear, the contract is void.
There are two aspects of uncertainty term that make the contract void. The first aspect is language used in the agreement is too vague. When the two parties using the different language, there will be misunderstanding between both parties. So the contract is void. The second aspect is when the parties fail to reach agreement on a vital term of an agreement, also known as a missing term. The general rule that no contract come into existence in essential terms are missing, such as price, date of delivery, description of goods. Although the language is clear, it means even the language is clear, but when the agreement have any missing term such as price, delivery date and description of good, the contract will be void.
As example, the case review that we can take is G's Camel and Nephew Limited versus HC and JG Hobson. The claimants wish to trade their old van for a new van with the defendants. They agreed a price for the old van trade-in, but only that they would pay for the new van on higher purchase terms for 2 years. The defendant subsequently pulled out of the agreement, and when the claimants attempt to sue, the defendant argued that the agreement could not be enforced because it was too uncertain. So the court held this was too vague for the contract to be enforced. There was no objective standard by which the court could know the price was intended or what a reasonable price might be.